Now, how do we stem this tide? How do we stop this? If we all know that there is a very knotty issue that brings about the stay of these proceedings, why can't we address it, Alede? The problem is that they know. Those who ought to change the laws, they know what to do, but they don't want to do it because it benefits them.
That has always been the problem, because loads of times people have always put the blame on your own constituency. It's saying that the lawyers are also responsible for all of this mess. When you talk about some unnecessary delays in these trials, they say we should ask the judiciary.
So let me tell you this. Yes, the blame is not always also on the defense lawyers. You can also blame in some cases the prosecution, and in some cases you blame the courts. But let me tell you how you can put everybody under pressure, both the prosecution, the defense, and the court. There's one very simple suggestion. And I've been shouting myself hoarse, nobody wants to listen to me. Those who are amending the Constitution should please listen to this and listen carefully, because I'm speaking authoritatively, because I'm at the heart of prosecution in this country. Now, there is a provision in the EFCC Act that says that interlocutory applications and appeals shall not operate as a stay of proceedings. In other words, if you are going on appeal on an interlocutory point, say jurisdiction, for example, or sufficiency of the proof of evidence, that it will not act to stay proceedings at the lower court. Now, despite this provision, almost all our cases are stayed at the lower court. Why? Because the defense lawyers will tell you that the Constitution guarantees the right of appeal. And part of the right of appeal is also the right to have your appeal heard first before your case is determined at the lower court. So, in many cases, they argue that the Constitution overrides the EFCC Act. And I've told a few of my colleagues, why don't we solve this simple problem, Alede? Just amend the Constitution and put it as a provision in the Constitution that there shall be no stay of proceedings in criminal trials. And criminal trials are deemed adjourned from day to day. Put it in the Constitution. If you put this provision in the Constitution, within 1 year, you don't need special courts. All these cases will be disposed of. So that nobody can raise constitutional provisions to defeat any criminal trial.
Do you think that's
put it as a provision,
or that was deliberately put there in the Constitution?
If some of my colleagues will say, oh, that is rules of procedure. That you don't need to put such rules of procedure in the Constitution. But of course, there are other rules of procedure in the Constitution that sneak into the Constitution. There are provisions as to leave to appeal, time to appeal. There are also provisions regarding the election tribunals as to the powers of the court to deliver judgment and the reserved reasons later. Those are rules of procedure. So the Constitution does not wholly deal with substantive issues. There are 1 or 2 provisions that deal with procedure in the Constitution. So why not put this rule of procedure there? And when you put it there, I bet you within 1 year, all these cases that have been hanging for the past 8 to 10 years will be disposed of. Either they are let go, they are discharged and acquitted, or they are convicted. Now, how do we balance the scale? If, for example, you say, you put in the Constitution now that criminal trials are deemed adjourned from day to day, and that except the judge otherwise directs. In other words, if the judge diary does not accommodate it, he can adjourn for 1 week or 2 weeks. But it should be deemed adjourned from day to day. And there shall be, it should be a compulsory provision, there shall be no stay of proceedings in all criminal matters. Now, when you put this provision, the accused person also has certain fears that you must take care of. What are the fears of the accused person? The accused person may have a genuine objection as to jurisdiction, for example, that is pending at the Court of Appeal. So what if he is convicted at the lower court and then he spends 5 years in prison, and at the end of the day, the Court of Appeal says, oh, sorry, there was no jurisdiction in the first place to try you? It's very simple. We can take care of this problem, and other countries have done it. Let us introduce suspended sentencing. Now, if, for example, at the point of convicting an accused person, the court discovers that, well, I thereby find you guilty on count 1, 2, 3, 4. But the defense lawyer may stand up and say, my lord, we do have an interlocutory appeal that has been pending at the Court of Appeal over jurisdiction of this court. The court say, okay, well, I've seen your appeal. I can see there are arguable grounds. What I will do is that I will not sentence you. I will suspend sentencing until your appeal is over. But you will go home on very strict conditions. Go and bring all the title documents of all your houses. Go and bring your travel documents. You must not travel out of the country. Go and bring 5 shorties or 3 shorties, as the case may be. And they can take you out on bail. Bail pending appeal. That's what they call bail pending appeal, which is also allowed by our laws. So that also takes care of the fears of the accused person, that he may have a genuine interlocutory appeal. Okay. And so when the appeal is over, you just come back for sentencing.
Mr. Keyamo, the National Assembly is preparing to amend the Constitution. Have you sent in a memorandum, or has the NBA sent a memorandum as regards these lapses in the Constitution?
I have told a few of them at a few sessions here and there that they held. And I've discussed it with a few of those who should also have been in positions to make these amendments. But I am repeating it again, and I'm telling them they should please listen to me. This is my suggestion, because like I said, I am at the heart of prosecution. I know the problems. Let them just put these provisions in the Constitution and see whether the prosecution will not work. Our hands are tied because of the rules of criminal procedure.
You know, in any case, one wonders when we talk about plea bargaining, how come it looks like the plea bargaining is only for some set of people? Perhaps maybe you should expatiate more. The man who steals, for instance, went into a barber's shop to steal a clipper. What can we say of that gentleman who is already in jail, and the man who actually admitted to pilfering the nation of over almost 24 billion naira is actually set off the hook because he's been able to pay 750,000 naira. Perhaps tell us more what the law says about this plea bargaining. Let's go into the details of it all and see how it affects our justice delivery system.
Well, it appears that, you know, we are running 2 sets of laws for the people of this country. And I do agree with you at times that some of these disparities, they do not make sense. They do not make sense to me. Okay? Now, the problem is that the politically exposed persons, we give them too much respect in handling their trials, in handling their prosecution, even in arresting them. An ex-governor tells you that, don't worry, you are looking for me, I will come in next week, Tuesday, expect me, and he's coming with a lot of fanfare and all that to the commission to make his statement. You know, whereas, you know, people who have done very small, accused of small offenses, I mean, at times they go to their house with truckloads of policemen to arrest them, you know, and throw them in prison, in detention, I mean, for weeks even before they grant them bail. So we must find a way to level, you know, the laws and the implementation of our laws as regards everybody. So that also brings me to the plea bargaining. The plea bargaining is that those also who are politically exposed persons, those who have stolen a lot of money, they have also a lot of money to plea bargain. That's the problem. A man who does not have any money, what do you want to offer? What do you want to offer? Even the money they took away from this police pension board man now is about 300 and something million. And that, of course, is chicken change when it comes to the money he stole. But where will
even lawyers
a poor man have even 50 million to plea bargain with? So you must have something in your pockets before you want to plea bargain. Now, coming to those who are also accused of simple offenses, don't forget that many of them are also remanded in prisons across the country, awaiting trial. So the problem is not only with corruption cases. Why are our prisons full of persons awaiting trial? Let me tell you how we can simply resolve that problem.